What started as a standard judicial proceeding transformed into a seismic legal upheaval. Justices John Roberts and Amy Coney Barrett ridiculed Pam Bondi, only to be unmasked shortly afterward. You won't believe what she disclosed that triggered their stunning collapse. The Supreme Court chamber grew hushed as Attorney General Pam Bondi stepped toward the lectern. The prominent case, centered on claims of judicial overstep, had captured nationwide scrutiny. But no one foresaw the drama that would unravel over the next few hours. Chief Justice John Roberts gazed down from the bench, his face a blend of scorn and restlessness. To his side, Justice Amy Coney Barrett reclined in her seat, a faint smirk barely hidden. The atmosphere in the room was tense even before any words were uttered. "Ms. Bondi," Roberts commenced, his tone laced with the polished command of years on the bench, "I trust you've prepared something more compelling than the documents your office provided." A few uneasy laughs echoed through the onlookers. Bondi, poised in her navy attire, carefully arranged her notes on the lectern. "Your Honor, the proof we've compiled is both significant and substantial," she responded. Barrett cut in, sharing a look with Roberts. "That's hardly the term I'd apply to a submission filled with conjecture and indirect links." The audience stirred awkwardly. Such overt antagonism was rare, even in the nation's highest court. Bondi tried to proceed, but Roberts raised a hand. "Perhaps, Ms. Bondi, you could clarify why we shouldn't immediately throw out this case for squandering the court's precious time." His tone was condescending, as if addressing a novice law student rather than the Attorney General. Bondi inhaled deeply. "If the court would permit me to fully present our discoveries." "We've reviewed your discoveries," Barrett interjected sharply. "They amount to little more than conspiracy theories cloaked in legal rhetoric." Several journalists in the press area exchanged glances. This was becoming unusually personal. Justice Mayer shifted in her seat, visibly uneasy with her colleague's approach. "The court acknowledges that you're relatively new to arguments of this scale," Roberts continued, his smile not touching his eyes, "but surely someone in your office could have cautioned you about the pointlessness of this tactic." The derision was unyielding. For 45 minutes Bondi endeavored to present her case while the two justices alternated interrupting her, challenging her competence, and occasionally sharing knowing glances that prompted uneasy chuckles from their clerks. "Ms. Bondi," Barrett said with exaggerated patience, "perhaps you could cite any precedent, any at all, that supports your rather imaginative take on judicial accountability." The dismissive tone made it clear they had already predetermined the outcome. Other justices remained conspicuously silent, some appearing troubled by the unusual display but reluctant to step in during the increasingly hostile exchange. "The American people deserve better than this theatrical display," Roberts remarked after another attempt by Bondi to explain. "This court has stood for over 2 centuries on principle, with all due respect, Your Honor." Bondi finally interjected, her voice steady despite the onslaught. "I have the floor." The room fell silent at her audacity. Roberts' eyebrows shot up in surprise, while Barrett's smile froze. "You have the floor at this court's discretion," Roberts reminded her icily. "And I trust this court still honors its own protocols," Bondi replied, holding his gaze, "including the right of presenting counsel to be heard without relentless mockery." The audience held its collective breath. No one spoke for several long seconds. "Proceed, Ms. Bondi," Roberts finally said, his voice taut with restrained anger. "But know that the court's patience is finite." Bondi nodded slightly, squaring her shoulders. The mockery had clearly defined the battleground. Two of America's most powerful jurists against a lone attorney standing at the lectern. What none of them realized was that the true conflict had yet to begin. The atmosphere remained electric as Pam Bondi resumed her presentation. The initial shock of her defiance against the Chief Justice had faded, but all eyes remained locked on the confrontation unfolding. "As I was stating," Bondi continued, her voice remarkably steady, "this case isn't about partisan agendas or undermining judicial authority. It's about safeguarding the very constitutional principles this court was founded to uphold." She methodically rearranged her notes, seemingly unshaken by the earlier barrage. Several observers noted the shift in her demeanor. Gone was any hint of defensiveness, replaced by calm resolve. "In the case of Thompson v. Federal Election Commission," she proceeded, "Justice Barrett wrote that judicial independence must be balanced with accountability. I quote, "No office, however esteemed, stands entirely beyond the scope of constitutional oversight." Barrett shifted in her seat, clearly unprepared for her own words to be wielded in this context. Similarly, Chief Justice Roberts, Bondi continued, turning her gaze directly to him. "During your confirmation hearings, you declared that judges are servants of the law, not the reverse. Would you agree that this principle applies universally?" Roberts' eyes narrowed slightly. "Ms. Bondi, are you attempting to interrogate members of this court?" "Not at all, Your Honor," she replied, her tone respectful yet resolute. "I'm establishing the foundation of legal principles that both sides presumably share, unless those principles are applied selectively." The subtle challenge lingered in the air. Several justices leaned forward, suddenly more attentive. Justice Kagan glanced at Roberts with an unreadable expression. Bondi pressed on, methodically building her argument. With each point, she referenced prior opinions authored by Roberts and Barrett, highlighting apparent inconsistencies between their past legal reasoning and their current stances. In Harmon v. State Department, she noted, nodding toward Roberts, "This court, under Your Honor's leadership, held that documented patterns of behavior constitute admissible evidence when establishing institutional bias. That precedent seems directly relevant to our current submission." The audience began to notice a subtle shift. What had started as one-sided mockery was evolving into a more balanced exchange. Legal reporters scribbled frantically. When Barrett attempted another dismissive interjection, Bondi countered with such precise citation of Barrett's own prior legal reasoning that the justice fell silent mid-sentence. "Justice Barrett, I'm simply applying the three-part test you established in Richardson, unless that framework no longer holds." Barrett's face flushed slightly, recognizing her own legal logic being turned against her. Throughout the exchange, Bondi maintained impeccable professionalism, no trace of sarcasm or derision, only precise legal arguments delivered with unwavering composure. The contrast was not lost on the other justices or observers. A murmur began to build among the legal experts present. What had seemed a foregone conclusion was now less certain. Bondi's command of case law, particularly the prior opinions of the justices attempting to dismiss her, was proving unexpectedly formidable. Furthermore, Bondi continued, "The documentation we've submitted demonstrates a pattern that cannot be dismissed as coincidental or speculative when viewed through the lens of this court's own established standards of evidence." She paused, letting her words settle across the chamber. "Unless, of course, those standards vary depending on who stands before this court." The implied question, whether justice was truly impartial, resonated throughout the room. Several justices exchanged concerned glances. The mockery that had defined the session's start had entirely dissipated, replaced by serious consideration of Bondi's arguments. Roberts cleared his throat. "Ms. Bondi, you have 30 minutes remaining. I suggest you focus on your substantive claims rather than rhetorical questions about this court's integrity." "With respect, Your Honor," Bondi replied calmly, "demonstrating this court's integrity is precisely why I'm here." The courtroom's mood shifted palpably as Pam Bondi reached into her briefcase and withdrew a sealed envelope. The confidence in her movements suggested that her next move had been meticulously planned. "Your Honors," she began, her voice clear and deliberate, "the Department of Justice has been investigating certain judicial irregularities for the past 14 months. Chief Justice Roberts straightened in his seat. "Ms. Bondi, if you're implying—" "I'm not implying anything, Your Honor," Bondi interrupted smoothly. "I'm presenting established facts." She broke the envelope's seal and extracted several documents bearing official government watermarks. "With the court's permission, I'd like to submit file JR 7923 containing internal communications between certain members of this court and external parties with cases pending before it." The silence that followed was profound. Justice Thomas leaned over to whisper to Justice Alito, whose expression grew visibly concerned. "Such evidence would be highly irregular and potentially inadmissible," Barrett said quickly, her earlier mockery replaced by a note of caution. Bondi nodded, as if anticipating the objection. "Under normal circumstances, perhaps." However, these documents were obtained through a FISA warrant approved by Judge Marcus Wilkinson of the D.C. Circuit, after preliminary evidence suggested potential violations of 18 U.S.C. Section 201. Murmurs erupted throughout the courtroom. Section 201 covered bribery of public officials, including federal judges. "This is outrageous," Roberts declared, his face reddening. "This court will not be ambushed with unverified. The evidence is thoroughly corroborated, Your Honor." Bondi continued calmly. "By whistleblower testimony from 2 former clerks and electronic records subpoenaed from 3 separate telecommunications providers." She placed the documents on the evidence table, where the court clerk sat frozen in shock. "Additionally, we have financial transactions linking Justice Barrett and yourself to the Westmoreland Foundation, which simultaneously funded advocacy for cases you failed to recuse yourselves from." The gallery erupted in gasps and hurried whispers. Several journalists bolted from the room, likely to file breaking stories. "These are serious allegations that warrant immediate," Justice Sotomayor began. But Roberts cut her off. "This session is suspended pending review of these purported documents," he announced. His voice strained as he rose from his seat. "Your Honor," Bondi called out firmly. "There's more." She gestured toward the back of the courtroom, where a man in a dark suit had entered quietly during her presentation. "Special Agent Ramirez from the FBI's Public Corruption Unit has additional evidence that was only declassified this morning." Agent Ramirez approached the bench, carrying a digital tablet and what appeared to be court orders. The room watched in stunned silence as he conferred briefly with the court's security personnel. "These transcripts," Bondi continued, now addressing the entire courtroom, contain recorded conversations explicitly discussing how certain cases would be decided before oral arguments were even heard. The evidence was damning, detailed, specific, and seemingly irrefutable. With each new document presented, the color drained further from Roberts and Barrett's faces. What had begun as their mockery of an attorney they'd underestimated had transformed into something unprecedented. The Department of Justice, Bondi stated, her voice now carrying the full weight of her office, has a constitutional duty to ensure that no one, regardless of position, stands above the law. Other justices appeared as shocked as the spectators, some staring at their colleagues with expressions of disbelief and betrayal, while others reviewed copies of the evidence distributed by court officers. Justice Barrett, Chief Justice Roberts, Bondi said, her composure now tinged with unmistakable gravity, these documents establish probable cause for criminal proceedings. The trap, carefully laid, had fully sprung, and the previously untouchable justices found themselves ensnared in evidence they couldn't dismiss or belittle. The legal battle had shifted irrevocably. What happened next would hinge on how they responded to evidence that threatened not just their positions but potentially their freedom. Justice Elena Kagan was the first to break the stunned silence that had enveloped the Supreme Court chamber. She leaned forward to examine the evidence spread before the bench, her expression somber. Chief Justice, these allegations appear gravely serious, she said, her practiced judicial neutrality barely masking her concern. Perhaps we should adjourn to review these materials properly. Roberts' face had gone from flushed to pale. This is procedurally unprecedented. The Supreme Court cannot simply be investigating judicial misconduct is well within established procedure, interrupted Professor Alan Hirschfeld, a constitutional scholar who had risen from his seat in the gallery. The Constitution provides no immunity for criminal acts, even for Supreme Court justices. Hirschfeld was not alone. Throughout the courtroom, legal experts who had come to observe what they thought would be a routine hearing began to voice their professional assessments. The evidence presented appears to meet the standard for judicial ethics violations at minimum, called out Judge Miranda Chen, retired from the Ninth Circuit and respected across ideological lines. The proper procedure now would be recusal and investigation. Barrett glanced nervously at Roberts, their earlier confidence gone. The gallery, filled with legal professionals, journalists, and citizens, had transformed from passive observers to active participants in what was rapidly becoming a historic turning point in American jurisprudence. Order, Roberts tried weakly, but his authority remained untouched on the bench. The dominance he had wielded so dismissively earlier mysteriously vanished. Agent Ramirez stepped forward again, conferring with 3 additional agents who had quietly entered the courtroom. They positioned themselves strategically near the exits and the bench. "If I may," Bondi spoke again, her voice cutting through the growing murmurs. "We have with us today Ms. Rebecca Carlton, former clerk to Justice Barrett." A young woman in a charcoal suit stood from the third row. "The communications and evidence match those I was instructed to delete from the official record in February. I have provided sworn testimony to that effect." Barrett's composure visibly cracked. That's simply not true," she stammered. But the force of her denial was undermined by the tremor in her voice. The mood had shifted dramatically. Other justices began to edge away from Roberts and Barrett, the physical distance reflecting the ethical chasm that had opened on the bench. "I've reviewed the financial transactions," announced Justice Brown Jackson, holding up one of the evidence packets. "If these are accurate, they represent clear violations of judicial ethics standards. They are authentic." "Your Honor," confirmed Agent Ramirez, speaking for the first time, his voice measured but authoritative. "The Bureau has verified each transaction independently." Roberts attempted one last defense. "This court has procedures for addressing concerns about judicial conduct. This public spectacle is not." "Those procedures," Bondi interjected, "assume good faith actors. When the highest arbiters of justice are themselves compromised, extraordinary measures become necessary." The gallery erupted in agreement. Law professors cited precedents, retired judges outlined proper protocols for judicial accountability, and even court staff began to view the 2 justices with new eyes, not as revered figures beyond reproach but as officials who had potentially betrayed their oaths. Agent Ramirez stepped forward again, this time with distinct purpose. He approached the bench directly, no longer waiting for permission. "Chief Justice Roberts." "Justice Barrett," he said formally, "I need to speak with you both immediately regarding these matters." The other justices exchanged glances, then began to file out, recognizing that the court session had effectively ended. As they departed, several paused to look back at their colleagues, some with disappointment, others with undisguised shock. The courtroom that had witnessed the mockery of Pam Bondi just hours earlier now stood witness to something unprecedented. The highest legal authorities in the land facing questions they couldn't dismiss with a wave of their hands. As Agent Ramirez led the 2 justices toward a side chamber, the gallery continued to buzz with conversation. The power dynamic had been completely reversed. Those who had wielded authority so carelessly now found themselves at the mercy of evidence they couldn't control. The side chamber of the Supreme Court, typically a sanctuary of judicial privacy, had transformed into an impromptu interrogation room. Agent Ramirez placed a thick folder stamped classified on the mahogany Before we proceed further in open court, he explained, you should be aware of exactly what the Justice Department has uncovered. With methodical precision, he opened the folder and arranged 7 documents in a neat row, each bearing the official seal of the United States government with top-secret SCI surveillance authorized stamped in red across the headers. This can't be legal, Barrett protested, her voice barely above a whisper. The Supreme Court cannot be subject to surveillance without. The surveillance was authorized under the Foreign Intelligence Surveillance Act, Agent Ramirez explained calmly. The initial target was not the court but foreign entities attempting to influence judicial outcomes. Roberts stared at the documents, his judicial mask finally cracking. Those communications were private, he murmured. Private, perhaps, Bondi replied, entering the chamber with 2 additional FBI agents, but not privileged when they involve conspiracy to obstruct justice. She lifted the first document. This transcript from April 13 shows Justice Barrett discussing the outcome of Fredericks v. Environmental Protection Agency before oral arguments were even heard. You stated, and I quote, "We've agreed this needs to go 6-3 to give it proper weight." Barrett's hands trembled slightly. That's completely out of context. Then perhaps this will provide context, Bondi continued, revealing the second document. Bank records showing transfers of $175,000 from the Westmoreland Foundation to Barrett Family Investments LLC 3 days after the Fredericks decision was announced, exactly as agreed in the communication. The room fell silent as the implication settled. Agent Ramirez unveiled the next document, a series of encrypted text messages between Roberts and external parties discussing specific cases pending before the court. The encryption was sophisticated, Ramirez noted, but not sophisticated enough to prevent decryption with proper authorization. Roberts' face had gone completely pale. "I want my attorney present immediately." "That's your right," Bondi acknowledged, "and will facilitate that request. But these documents are being unsealed as we speak in the main courtroom. The American people have a right to know when their institutions have been compromised." Back in the courtroom, a Justice Department official was addressing the gallery and remaining justices. Large monitors had been set up, displaying the previously sealed documents with sensitive information redacted for national security purposes. "What you're seeing," the official explained to the stunned audience, "is evidence gathered over 14 months through legally authorized surveillance activities, originally targeting foreign influence operations." The screens displayed message logs showing coordination between the 2 justices and external organizations with cases before the court. Financial records revealed patterns of payments disguised as speaking fees and book advances that coincided suspiciously with key decisions. Most damning were the recordings, actual audio of Roberts and Barrett discussing how certain cases would be decided, regardless of oral arguments or the positions of other justices. "We'll need Thomas and Alito on board, but that's never been a problem," Roberts' voice echoed through the courtroom speakers. "The others don't need to know about our arrangement." In the side chamber, Roberts and Barrett listened to their own voices with growing horror, realizing the full extent of the evidence against them. "How did you get these recordings?" Barrett demanded, her legal training giving way to personal panic. "A concerned party within your chambers," Bondi replied simply. It seems not everyone was comfortable with the direction the court was taking. As the sealed documents continued to be revealed, both in the private chamber and the public courtroom, the magnitude of the conspiracy began to take shape. This was an isolated misconduct but a systematic effort to manipulate the highest court in the land. In the main courtroom, legal experts and journalists watched in disbelief as years of judicial decisions were suddenly cast in a troubling new light. The unsealed documents told a story of influence and corruption that shook the very foundation of American jurisprudence. The atmosphere in the side chamber grew increasingly tense as Agent Ramirez reached into his jacket pocket and produced 2 folded documents, each bearing the official seal of the U.S. District Court for the District of Columbia. Chief Justice John Roberts and Associate Justice Amy Coney Barrett. He began formally. "I have been authorized to serve you with these federal arrest warrants pursuant to probable cause found for violations of bribery of public officials, witness tampering, and obstruction of proceedings." He placed the warrants on the table between them. The documents seemed to carry a physical weight beyond their paper and ink. They represented something unprecedented in American judicial history. "This is absurd," Roberts sputtered, not reaching for the warrant. The Supreme Court has immunity from political interference," Bondi corrected. "It has never had immunity from criminal prosecution. No American does." Barrett's legal mind seemed to catch up faster. She glanced at the warrant before her, noting the signature of Judge William Harrison, a respected federal judge known for his meticulous adherence to procedure. "These warrants were properly obtained," Agent Ramirez explained. After presentation of evidence to a grand jury, indictments were returned against both of you yesterday afternoon. The records were sealed until this moment to prevent flight risk or destruction of additional evidence. Through the door, they could hear the ongoing commotion from the main courtroom as the public and press reacted to the documents being displayed. The carefully constructed narrative of judicial propriety was collapsing in real time. Roberts attempted one last assertion of authority. This is a constitutional crisis. You cannot simply arrest sitting Supreme Court justices. The constitutional crisis, Bondi replied calmly, began when justices of this court sold their integrity,